On August 7, 1935, the Philippine legislature enacted the Probation Act No. 4221, creating a probation office under the Department of Justice, led by a chief probation officer appointed by the American Governor-General, with the advice and consent of the United States Senate. This law provided probation for first offenders 18 years of age and above convicted of certain crimes. It stayed only for 2 years.
People v. Vera, it challenged the constitutionality of Act 4221 on 3 grounds. First, encroaches the pardoning power of the chief executive. Second, it constitutes an undue delegation of legislative power. And lastly, it denies the equal protection of the laws.
On November 16, 1937, the Philippine Supreme Court declared People v. Vera case as unconstitutional. It ruled that said law contravened the equal protection of the law clause, as it surrendered to provincial boards of each province the power to appropriate or not funds for the establishment of provincial probation courts. House Bill No. 393, filed by Teodoro C. Natividad and Ramon Bogot Singh. This is the second bill or measure that attempts to establish an adult probation in the Philippines. It was passed in the lower house but pending in the Senate, when martial law was proclaimed.
Presidential Decree 968, it is known as Probation Law of 1976. This was signed into law by then-President Ferdinand Marcos on July 24, 1976 during the last day of the First National Conference on Crime Control held at Camp Aguinaldo. January 3, 1978, the effectivity of the application of the substantive provisions concerning grant of probation. Teodoro C. Natividad. He is the former Napolcom Commissioner and former Congressman of Bulacan. He is known as the father of probation in the Philippines. Is there a form prescribed for the application for probation? The answer is yes, it shall be in the form approved by the Secretary of Justice, as recommended by the Administrator, or as may be prescribed by the Supreme Court.
Where can we file the application for probation? The application for probation be filed directly to the trial court that heard and sentenced the person applying for probation.
What then be the duty of the court after receipt of the application? The trial court may notify the concerned prosecuting officer of the application, at a reasonable time before the scheduled hearing thereof.
These are procedures in applying for probation. First, the offender or his counsel files a petition with the convicting court. Second, the court determines convict qualifications, and notifies the prosecutor of the filing of the petition. Third, the prosecutor submits his comments on such application, within 10 days from receipt of the notification. Fourth, if petitioner is qualified, his application is referred to the probation officer for post-sentence investigation. Fifth, the post-sentence investigation report is submitted by the probation officer to the court within 60 days, and lastly, the court grants or denies the petition for probation within 15 days upon receipt of the post-sentence investigation report. Effects of filing an application for probation. The court may, upon receipt of the application, suspend the execution of sentence imposed in judgment. Pending the submission of the post-sentence investigation report, and the resolution on the application, the applicant may be allowed on temporary liberty, under his bail, on a new bail, or released on recognizance. The following are the disqualifications for probation. Those who were sentenced to more than 6 years. Those who were convicted of crimes against the security of the state as stipulated in Article 134 to 157 except 135, 140 and 152 of the Revised Penal Code. Those previously convicted and punished, of not less than 1 month and 1 day imprisonment and, or fine of not less than 200 pesos. Include those punished with destierro. Those who were previously granted probation under PD 968.
and those who were already serving their sentence, when probation became applicable.
The court will not grant probation if it finds the offender can be treated better in a mental institution or other places for correction. The offender is a risk to the community, and the offense is grievous to the eyes of the community. When probation is granted, what conditions are imposed by the court? It is when the probationer must present himself to his probation officer within 72 hours. Report to his probation officer at least once a month. Not to commit another crime. And comply with any other lawful conditions imposed by the court. If the probationer committed a crime while under probation, what would be the consequences? The probationer will be arrested for violation of the condition of probation, prosecution of the new crime committed, and the court will order the serving of the original sentence of the previous offense. How long is the period of probation? It should not more than 2 years, if the sentence is imprisonment for 1 year or less, and not more than 6 years, if the sentence is imprisonment for more than 1 year but not more than 6 years. Note: probation starts upon issuance of the court granting probation. When can the court modify the conditions for probation? At any time during supervision. After summary hearing when the probationer violated any of its conditions, and upon application by the probation officer, or the probationer himself. Note: only the judge who heard and decided the case has the power to grant, deny, modify, revoke, and terminate probation. Change of residence. The probationer must file a request for change of residence at the city or provincial parole and probation officer to the court approval. If approved, the regional trial court, which has jurisdiction over the place, shall have full control of the probationer.
There are 2 ways of terminating probation. First, after period of probation with satisfactory compliance with conditions of probation. Second, other ways of terminating probation. Termination before the expiration of the period, but served at least 1/3 of the imposed period, but not less than 6 months. Termination by pardon of the probationer, either absolute or conditional. Deportation of the probationer. When an alien on probation is deported, probation will necessarily be terminated. And the death of probationer. How can community help in the success of probation? Community accepting the probationers, giving them a feeling of belongingness. Community agencies and schools are being opened for the training and treatment of probationers. Community leaders and laymen, allowing the participation of probationers in developmental programs.
Religious organizations, giving the probationers spiritual advice, and extending their social action programs to probationers. Various organizations, providing temporary housing for probationers. And the community playing an equally important role. After the termination of probation, it should be ready for the reintegration of the individual into community life. I hope you learned something in this video.